All right, our second case is 22-60498 Affordable Care LLC versus JNM Office Property LLC. Ms. Cundiff, are you ready to proceed? Did I pronounce that correctly?
I'm sorry?
Did I pronounce that correctly? Is it
Cundiff?
Cundiff?
Yes. Got it. You did perfectly. Good afternoon. I'm Nancy Cundiff here on behalf of Affordable Care LLC. I tend to address today primarily whether there's an actual material issue of fact as to Affordable's alleged waiver of objection to its overpayment of rent that was made to its landlord over the course of many years, based on that landlord's misrepresentation of the actual amount of construction cost. So because we have a counter appeal, I will also be addressing whether the jury's award of punitive damages at our trial should be reversed. And if the court would like, I can address whether the underpayment of $1,400 in a CPI increase on rent is a material breach. I'm hoping we don't have to spend too much time on that because that seems like sort of self-evident and from the briefing. And Judge Ozerden actually gave us a very well-reasoned opinion on that issue. But the lease in this matter contemplated a rent amount that would be based on total construction cost. So that included the land cost, construction financing cost, and all construction costs thereafter. Now, ultimately, what we discovered once this litigation ensued was that the total cost of construction cost had been grossly overstated by the landlord. And Affordable Care did take them at the number that they were given, and then thereafter continued to pay rent based on that amount. JNM actually at page 52 of their brief concedes that there's no genuine dispute that Affordable had a known right under the lease for the minimum actual rent, annual rent, to be calculated based on that defined formula on the lease. So all the costs added together, multiply it by 10.25%, which gives the landlord some profit there as well, and then you divide that by 12. So you get your annual rent and then your monthly rent once you divide it by 12. So the issue that we ran into was 3 elements of waiver. So basically the court on a motion for summary judgment determined that we had argued that there had been gross overpayment of rent based on the misrepresentation of the total amount by the landlord. The landlord represented it was $2.5 million. Once we got into discovery, we realized the most that the construction cost could have been was a little over $1.8 million, a really tremendous difference. On summary judgment, the trial court decided that Affordable Care had waived objection to that amount because it had continued to pay rent based on the landlord's representation for more than 5 years at that point. Now, waiver under Mississippi law.
Let me ask something because I should know this. I shouldn't have to ask.
Sure.
Where was it written? There was an agreement between the parties of how the rent was to be calculated. I mean, a written agreement. I had the idea that somebody just said, well, it was roughly $2.5 million or whatever the number was. Was there any place where that actually governed what the number would be?
Yes,
in writing?
Excuse me for just a moment. That's found in the lease that the parties had with each other, and that is found in the record at 3205 is the first page of the lease. Now, so basically, this lease was to cover a property that was going to be built. They first entered into the lease in 2013, contemplating that JNM was then going to go buy the land, build the building, and then at that point, Affordable was going to lease the building from JNM. So in the lease, it provides a section, beginning in section A, but page 2, it provides this formula. So it contemplates, okay, landlord, you're going to go build this building, you're going to incur construction financing costs, you're going to incur the cost of buying the land, and you're going to incur all of the construction costs. Once you're done, we're going to total all those costs up. The lease also incorporates plans that were approved by Affordable Care as the tenant. So the plans are a key part of the lease because Affordable Care is saying, we're going to pay for this building at the construction cost as part of our rent. That's going to determine it. But it's based on these pre-approved plans and nothing else. So here's where things really get off the rails when they get the estimate from JNM. They're getting ready to move in, building's been completed, certificate of occupancy is issued, they're moving in, going to begin operating affordable care calls. The principal of JNM says, where are we at? Where are the construction costs? Now, keep in mind, these parties have already been in business together for well over 12 years at that point. They have a very good and lucrative relationship. And the principal of JNM says, all in, when we're done, it's going to be $2.5 million.
Approximately.
Right.
I mean, I had the idea that a hard number was not put down as a hard number. Was there some fudge language about approximately or what?
The lease provides...
Or maybe the way the question was phrased. I mean, when that number, 2.5 million, was put out, was it put out as fact or an approximation?
It was put out as an estimate. Here is my estimate of all costs incurred. Here's where it gets tricky. When Affordable Care was calling, they were asking for your estimate of, because you don't have your final numbers yet, that's fine, but we need to go ahead and start paying you rent. We're asking for your estimate of all costs incurred to construct the plans that had been previously approved, and as incorporated as part of the lease, not for any and all costs incurred for what you want to build and add on to the plans thereafter. And that's what we found once we got into it, that estimate given by JNM included a lot of other things that were not part of the plans. So Affordable's calling and saying, hey, we got to get you the rent. It's based on the cost of construction as per the lease. The cost of construction are based on the cost to construct these plans that we previously agreed to. What are your cost of construction for finishing these plans? And that's the number they were given, was 2.5 million. Unfortunately, that 2.5 million did not just encompass the plans. It encompassed a whole lot of other things, like building out an entire second floor. That was not part of the plans.
Whose idea was that?
That was entirely JNM. That was not something that Affordable would have been party to. It happened actually after this estimate was given to Affordable. Affordable did not understand that when JNM was giving it this estimate, Dr. Neil McIntyre, who was the principal, who was also a dentist that was going to continue practicing using that building that Affordable Care had leased as part of their business affiliation agreement, he's the one that gave Affordable Care that estimate. And he was apparently considering everything that he intended to build in the future, including finishing out the second floor. But that was not part of the plans, and that is not what the parties had agreed to be included in that total cost of construction that would later be what the rent was based on. Does that answer the question? I mean, yeah. So you're still frowning. So.
No, I mean, it's just that.
If at the beginning everybody understood it to be an estimate, is there a reason why at some point in time a concrete number was not asked for or requested?
I think it's just the parties' relationship was such that Affordable probably felt, this is me speculating, that we have a good relationship. Why would we ever expect that JNM would give us an estimate that would be not even close, at least 30% more than what their actual costs were? So, there was not a lot of, I think, on either side. Things were going well. It was a lucrative relationship. They've been in business together for a long period of time. As JNM stated in its brief, the Rick Edwards at that time, who was the founder, the Affordable founder's son, was who Neil McIntyre was dealing with. I mean, they're Affordable, this is also in JNM's brief, but Affordable had actually talked to the McIntyres at one point when they said, we'd like to, build our own building and then lease it to you for this continued business operation. And Affordable actually said, you need to get a real estate attorney. So they were working together. It was a very cooperative relationship. It seems reasonable that under that circumstance, they had no reason to believe that they would have been told not just an incorrect figure, but a grossly incorrect figure that was never corrected. I mean, 2.5 million, that JNM borrowed money for this project. Surely at some point they would have realized that's not even close to what we borrowed or what we spent with the completion. Even with all of the additions, there was over $100,000 alone spent on landscaping. That was after Affordable had already taken possession, was already operating within the building with the JNM principals, Dr. Raylene and Neil McIntyre, operating their dental practice within. It may be helpful for me to back up just a little bit and explain sort of the Affordable Care structure, because what they do is they're a dental management company. They're all over, they have locations throughout the country. And what they do is they lease properties, they completely furnish those properties as dental practices. They, equipment, all of that. To open a new dental practice straight out of dental school would cost upwards of $1.5 million these days. Affordable provides that. They provide basically a turnkey office, and then they enter into an affiliation agreement with a dentist who then operates their practice there. Also, Affordable Care will continue. They specialize in dentures. They specialize in serving an older population. And then they continue by operating an actual dentures lab within that office. So you'll see some testimony about an Affordable Dentures employee who showed up to work and was prevented from entering the premises. That's what was going on. Affordable Dentures had its own lab, still within the building, entered from the side, and they made dentures there. So the dentists are there operating their dental practice. Affordable has leased the building. They are then subleased back to the dentist so they can operate their practice within. But then at the same time, Affordable still has its dentures lab within that same building. So the two are working together. Does that help some when I explain how the operation? So you have the McIntyres who had already worked with Affordable Care as an affiliated dentist for more than 12 years when they entered into this agreement that, okay, we the McIntyres want to own our own building in Gulfport, and then we have something in investment where we can make money in the future. And so Affordable, if we do that, will you lease from us? Yes. And the parties work together. They develop plans for construction of the building, and those plans are agreed on and encompassed into their lease. So at no point was that incorrect statement of 2.5 million ever identified to Affordable Care by anyone, whether.
Now, when they've, who is it that said, okay, your first rent check should be in the amount of? Who put that piece of information into it so they could write a check?
Well, according to the deposition testimony of Dr. Neil McIntyre, he was, when they were preparing to move in, and the certificate of occupancy had been issued, but perhaps there were still some things outstanding like punch list items, he was contacted by Rick Edwards with Affordable Care to say, hey, what were your construction costs? We need to figure out what we're paying you. We need to pay you a rent check as of, I think it was September 1st, 2014. So he contacted him. He had to get that amount for construction costs. That was not something that was in Affordable Care's possession. Now, an argument's been made that, oh, Affordable Care should have known because this lease, as to the construction, it does give Affordable Care the authority to act as an agent on construction procedures. But there is, so in other words, Affordable Care could come in, fly in occasionally, look at the progress of the building, weigh in on how things are being constructed. There's nothing there that gives Affordable Care the purse strings. Affordable Care, the record shows, did not purchase the land. They did not take out the loan to finance this construction. They weren't the ones dealing with the bank and getting the disbursements periodically. They didn't hire the prime contractor, the general contractor, or the architect, or anyone for that matter. That was JNM. And then JNM was the one controlling the purse strings and paying for everything. So Affordable Care didn't have access to those invoices and those charges. And in fact, we only got this information. We never obtained it from JNM. We sent discovery. Once we realized there was an issue here, there was a lot of questions about the costs that we were given. We got it by issuing subpoenas to the bank for the issue of the construction loan. And they produced their documents. And I believe we also issued a subpoena to the general contractor at some point. So the argument that, well, Affordable Care should have known, no, they weren't. They had construction supervision. That does not equate to they were the ones actually keeping track of the cost or monitoring the financial side of the project. Another big issue in this was the punitive damages that were awarded. And I just want to make sure the court is aware that obviously that it was a jury decision to award punitive damages. At trial, we awarded a little over $80,000 in compensatory damages. That was related to the McIntyre's, the JNM's decision to wrongfully push Affordable Care, block it from having access to the building for over a month. And eventually, we obtained a court order directing JNM to give Affordable Care access back. During that 1 month, however, they were out of possession of the building. Now, testimony shows that, first of all, JNM did not present any case at all at trial. We called witnesses. When it came their time, they closed. There was no evidence presented by JNM. The testimony shows that this was planned well in advance. There was obviously a knowledge by Dr. Raylene McIntyre and Neil McIntyre that Affordable Care had a valid lease. There were a lot of questions about the day of evicting Affordable Care, they already had, there's like a billboard type sign in front of their premises, very large. They already had purchased an actual cover for that sign that said McIntyre Dentures. That's not something that happens overnight. Affordable Care's employees testified that he showed up, he was locked out, he was not able to get into the premises. There was a lot of advanced planning while having knowledge that Affordable Care still clearly had a valid and binding prime lease.
Thank you. You've reserved time for rebuttal. Mr. Sun?
May it please the court. I'm Paul Sun. Kelly Dagger and I represent JNM office property. The principal issues in this case arise from the parties' lease. This is a lease. It's a form lease, an Affordable Care form lease. JNM is the lessor. Affordable Care is the tenant. And it provides an office building for Dr. Raylene McIntyre to operate her dental practice. JNM is Dr. Raylene McIntyre and her husband, Dr. Neil McIntyre. So that's JNM, and that's the parties' lease. And it's a fundamental principle of Mississippi law, and Mississippi law applies here, that if there is clear and unambiguous language in a contract, a lease is a contract, it will be enforced. Two issues here decided at summary judgment by the district court both turn on the clear, plain, and unambiguous language in the parties' lease. JNM asked the court, first of all, to decide that the district court erred in granting summary judgment in ruling that JNM could not terminate the lease when it had an express contract right under the lease to terminate. That was an error. At summary judgment, as counsel just addressed, also the district court ruled that Affordable Care waived any claim for alleged overpayment of rent because it waived a formula in the lease under the plain language of the lease that said this is how you are supposed to calculate rent. And Your Honor asked a question about that, and I'll invert the order of my argument to address first the waiver argument. It's a plain language argument again. The plain language of the lease, and this is in paragraph, or let me give you the record on appeal. The lease is at pages 3205 to 3220 of the lease. And the calculation of rent is in paragraph 5 of the lease. This is how you calculate rent. It's based on 3 variable inputs: land costs, costs of construction, and construction financing costs multiplied by an investor return factor, 10.25%. So that's the plain language of the lease. That says how you are supposed to calculate the lease amount to be paid, and it's called minimum annual rent. Important here, and this goes to the heart of this issue of alleged overpayment, cost of construction is defined again in the lease, and this is defined actually in paragraph 2 of the lease, as all costs paid. So Your Honor asked about a hard number. What the lease says is there's supposed to be a hard number because they're supposed to base it on costs paid by the landlord.
For the pre-approved plans?
Costs paid by the landlord.
Right, but for whatever plans were approved between the parties, or?
For improvements based on approval, yes, Your Honor. And I'll address here a comment again about purse strings. Who's got the purse strings here? The lease gives Affordable Care knowledge and control. This is in paragraph 2, as noted in the argument. Affordable Care is the agent of JNM for purposes of all construction activities. That gives them the basis to be both knowledgeable and to control. And where's the purse strings? This is in paragraph 2B of the lease. What it says is Affordable Care agrees to review all applications for payment, that's the knowledge, and to approve them as being appropriate for payment by the landlord. So who's got the purse strings? Affordable Care has the ability under the lease to control that. And that's critical, again, the way Affordable Care has set up this lease. It's going to be the tenant here, but its costs, its rental costs are going to be based on what's input, land costs, cost of construction, and construction financing costs. And construction financing costs, they have the ability to determine by reviewing everything that's a request for payment and then certifying that this is okay to pay. Well, Affordable Care didn't do that. And they've admitted they didn't do that. And they're still saying, yet, not our problem. Well, it is their problem under the lease because the plain language of the lease gives them that ability. I do want to address the question of the alleged overpayment based on misrepresentation. And JNM disputes that there is a misrepresentation about the total cost. First of all, Judge King, as your question focused on, Dr. Neil McIntyre, when asked by Rick Edwards, said, I don't have the costs. I don't have those readily available. And he was importuned with urgency by Rick Edwards to give him a number. And so his comment was, and this is in his deposition, somewhere around 2.5 million. Somewhere around 2.5 million. And importantly, construction is still ongoing. Construction isn't finished. But what Dr. McIntyre gave was what he called an all-in number. So anticipating that the total cost when they're all in for the construction would be 2.5 million. That was his estimate. And who set the rental rate? Rick Edwards did. And I could cite to the court page 4626 of the record. That's an email from Mr. Edwards. And what he does, he calls what Neil McIntyre gave him swag, a scientific wild ass guess. We're going to use this swag, and here's the number, 21,354.16.
I'm going to say that again. 21 what?
21,354.16. So down to the penny. They understand that there's a formula here that's supposed to be down to the penny. And he says that's what, and this is an internal communication, this 4626 in the record, internal communication. Pay this amount. We're starting in September. But he also says we should get a final by October and put a note on the calendar to check back about this. So he knew it was an estimate. He knew costs were ongoing. Whether or not he was paying attention to exactly how the lease said the cost paid was the input. He said, we got to check this. There's no evidence that they did. No evidence that Affordable Care checked as Mr. Edwards said in his own internal communication. So that's August of 2014, right before the lease kicks off. Lease kicks off as of September. Then in March of 2016, and this is in the same email string, and so this is at page 4625. The emails, although in chronological order, the pagination is sort of backwards. So this is a later email, 4625. Again, an internal communication at Affordable Care, and copying the same people. The question is, did we ever get these costs? The auditors are asking whether we got the costs. Again, no evidence that Affordable Care ever did anything. They knew they didn't have the number. They knew they should be asking for the number, and they didn't.
Now, whose auditors were asking?
Affordable Cares.
Okay.
So they're paying $21,354.16 beginning in September of 2014, and they pay that every month, 60 months for 5 years without raising a question. And again, JNM disputes that there was some overcharging based on this rental amount. But critically, to the district court's ruling, the district court said, well, you've waived that. There's a formula for how you're supposed to calculate rent under the plain language of the lease, and you intentionally decided not to do that. And you intentionally decided not to do that, even though also, and that's paragraph 5 of the lease, this is how you're supposed to calculate rent.
It says you decided not to do it. I'm sorry, I didn't follow. Who's you?
Affordable Care decided not to follow the formula in the lease when it set the rent amount. It decided to use an estimate rather than cost paid, and decided to go all in, even though construction costs were still ongoing. And I want to highlight here also, through rent years 1 through 5, the rent can be different because costs could continue if the construction is not completed when they first get in the building. Costs can continue to accrue, and then those become part of the formula for the rent.
Well, somebody told the construction company, presumably, was there an architect?
There was an architect.
Yeah, so the architect, we're going to put a second story on. I mean, who in here was the grown-up? Who was monitoring the costs? Because that's the key component.
So Affordable Care had a project manager. Sherwood Oglesby and that's his term. When they put out a bid for the construction, and ultimately Mr. Myrick becomes the general contractor. But on the bid, it says project manager Sherwood Oglesby, Affordable Care. He's an Affordable Care person. And according to Dr. Neil McIntyre's testimony, it was Sherwood Oglesby who suggested that they put in the second floor.
I'm sorry.
That the second floor of the office building be added. The plans are not in the record. We would have liked to have seen and been able to test, is this assertion that this is inconsistent with the plans? But the plans aren't in the record. Sherwood Oglesby's idea was to use, or suggestion was to put in the second floor. And so
Wait a minute, so who is he again? I'm losing.
He's the project manager, but he is an Affordable Care employee.
Okay.
So, waiver, intentional relinquishment of a known right. It is a known right. It's in the contract. And what we cited, and actually Affordable Care cited, the key case on this is Upchurch Plumbing, a Mississippi Supreme Court case. And when you're looking at waiver, first of all, if you have a known right under the contract, the known right is this formula. You have sufficient information to know that there is a deviation from the contract. They knew there was a deviation from the contract because they said this is how we want to do the rent. They intentionally decided not to follow the formula in the lease. And then the third test, act inconsistently or fail to require the contract to be followed. And they did both. They didn't require the contract, the formula to be followed. That's number one. And they then acted inconsistently with it by paying for 5 years without a complaint, even though, again, internally they're saying, hey, we need to check this. Somebody check this. Do we ever have the numbers? So the district court got it right in holding that there was waiver there. Let me switch to the other principal issue in the case. And that is, again, under the plain language of the lease, JNM, as the landlord, had a right to terminate if Affordable Care fails to pay any, underline any, rental payment as required in this agreement being the lease, and continues to fail to pay for 5 days after receiving notice. Fails to pay any rental payment. Looking again at paragraph 5 of the lease, beginning in year 6, there is a CPI adjustment. Under the lease, you take the then existing rent, which is the rent for rent year 5, and you multiply it by a factor based on the consumer price index. So what it does, it allows the rent to go up if costs are increasing. And again, that's part of what's going on here. There's an investor return idea. But that's the formula. That's what it says. Beginning in rent year 6, this CPI increase kicks in. And it's an increase. It's an increase. But when Affordable Care pays its September rent, they don't include the increase. They pay the same amount that they've been paying all along, $21,354.16. They don't pay the increase. Affordable Care then gets notice from JNM that you haven't paid what JNM calls the escalation amount, the CPI addition. That's in the record received by there's proof of delivery, and it's talked about internally. There's an email where they're talking about that, and they're on notice. So that's the notice. That's the express plain language of the contract. You can terminate if there's a failure, if Affordable Care fails to pay any rental payment as provided in the lease, and they didn't. They didn't. And they got notice from JNM, and under the plain language of the lease, JNM was entitled to terminate. The district court disagreed and said, no, there has to be a material breach. There has to be a material breach, and decides as a matter of law or at summary judgment that this is not a material breach. It's about $1,400 a month is the calculation, and that's not paid. And it has to be a material breach, and that's not a material breach. So 2 points here. It doesn't have to be a material breach. Under Mississippi law, and we cited the Clark case and the Columbus Hotel case, if there is a termination provision, it is valid and enforceable. Columbus Hotel says it will be enforced if there's a legally valid contract, and no one is questioning that the lease is a legally valid contract. So it can be enforced. And there are cases that say you have to have a material breach, but the case that we've highlighted, and the district court talked about this, and Affordable Care talks about this, is a case called UHS Qualicare. That's a Mississippi Supreme Court case that says when you've got a lease termination clause, there does have to be a material breach, but the parties can say it doesn't have to that doesn't have to apply if they do so clearly. If they do so clearly. And that's what we've highlighted, that these parties did so clearly by saying failure to pay any rental payment as provided. You can't be more clear than that. And by way of comparison, that's exactly the kind of language that was in Clark. There, the payment wasn't monthly checks or anything, it was notes. And what Clark says, the termination provision, if the tenant fails to pay any of these notes, when they come due, then the landlord has the right to both dispossess and accelerate. And that's what the lease gives here. And so the parties did clearly say that it didn't have to be a material breach, and they could want to do that. And why is that? Well, materiality is a question of fact, and I know the court would be familiar with lots of law on that. And that is the case under Mississippi law. Materiality is a question of fact. And what the UHS Qualicare case said is, it is an imprecise and flexible schedule. So rather than let there be a question whether some failure to pay rent might or might not be a material breach that would allow for termination, the parties said any failure to pay a rental payment is sufficient for termination. And they carry through by showing further in that same section. Failure to pay rent is treated separately. It's in subsection A. It is the only breach that has a short notice period, has a 5-day notice period, and it's the only kind of breach that allows acceleration in total default. So every indication that the parties could give, they gave that this would be an enforceable termination right for the landlord under the plain language of the lease, and that's what we're asking this court to do, follow Mississippi law. And in doing so, it would find that the district court erred in concluding that JNM could not terminate the lease and the lease was in full force and effect. Thank you.
Thank you, Mr. Sun. Ms. Cundiff?
Judge Douglas, to respond to your question regarding improvements as defined in the lease, it actually defines improvements. It states, improvements shall mean the approximate 4,373 square foot building, including all paving, outside lighting, landscaping, utility services, signage, acceptable to tenant, and other work contemplated herein, constructed substantially in accordance with the plans, hereinafter referred to as the plans, which were attached to leases Exhibit A and unfortunately did not make it into the record. Now, I know that this contemplates a 4,373 square foot building. The McIntyres testified as part of the record that the completed building was well over 5,000 square feet. At no time ever did anyone from Affordable, and they testified to this, approve construction of a build out of the second floor. It actually looked like it had been a homeschool or something for the McIntyres children, but it had a full bathroom. There was a Bosch stove installed at some point. Affordable Care verified that was never approved by them or contemplated by them. As to the testimony by Neil McIntyre regarding Sherwood Oglesby, I think actually Dr. McIntyre said something along the lines of, some places have done this, have finished out their second floor. The plans are similar to those used at other Affordable Care locations. They're sort of a template they work from.
So the idea never was to put a second floor on there.
No, ma'am, it's not.
Somebody put one. Who authorized the construction, did the diagrams and so on, the plans for a second floor?
It would have been done after Affordable Care was already done with its part of the construction. In other words, Affordable Care received, there was a certificate of occupancy. At that point, the dental practice moves in, the denture lab moves in, and they begin operating. All of this happened after that. All of it happened well after.
The second floor was constructed after that?
Yes, ma'am. So I guess there's a space where a second floor could be in this template that they have, and that perhaps is what Mr. Oglesby pointed out, but it's not actually built out in a normal Affordable Care location. So in this situation, they came in and they actually finished it out. So that was something.
Who was they?
The McIntyres. I mean, that was not something.
Okay.
Affordable Care has no need for an apartment upstairs in one of its dental locations. It has no need for, there was an aviary that was constructed behind the building that was as big of a house. That's not something Affordable Care would have any interest in investing in, nor would it invest in $100,000 in landscaping for what's basically a commercial office building. So those were not improvements that were approved by Affordable Care, and there's no evidence of such. Additionally, even with all costs that we could find, it only came to, I think, a little over $2.1 million. So there was certainly never any approval of Affordable Care to give this additional.
But I think I understood Mr. Sun to say even if there was an approval, that you had the authority or the ability to approve them, it just was never done. Did I understand his argument correctly? And if so, what's your response to that?
I would think that Affordable Care would have the ability to approve an improvement during the actual construction phase, which the lease discussed. After that, Section 14 of the lease states that the landlord, in its own discretion, if it wants to make improvements to its building, it can. And that is not something that it requires Affordable Care's approval. So what we're referring to is the actual construction phase up until when they took occupancy. And again, waiver presupposes full knowledge of a right existing and intentional surrender or relinquishment of that right. It requires sufficient information to be on notice of the alleged deviation from the contractual duty. That's the Upchurch decision. As far as
Did anybody in this outfit, does either of these two outfits have auditors?
Well, it seems that Affordable Care at some point had an auditor that asked about it, but that question was never answered. And that's all, we're looking back 7 years. And for whatever reason, it appears Affordable Care chose not to ever delve into the actual cost of construction. At the same time, it appears that they also had no reason to, that they had a relationship with the entrepreneurs, the McIntyres. And at that point, they were still operating in harmony with them. And there was, from that standpoint, we have a profitable location here. Let's keep rolling along. So is that a waiver? They were never actually given the information. They were never actually given the invoice and the cost. And regardless, they certainly never waived or agreed to pay for improvements that were not encompassed within or this lease. And there's nothing in this lease that says we're going to agree to pay for your additional second floor. That's how can that be waived when that was never even contemplated between the parties?
And there's no tax returns in this case, right?
Correct.
Jesus.
On the notice matter, what I can tell you, well, it looks like I'm out of time. However, the brief does fully address the adequacy of that notice.
Thank you for your argument. This case will be submitted. Court is adjourned until tomorrow at 1.